committee considered the nomination of an individual named Emil Bovy to go on to the Third Circuit Court of Appeals. At the time that we did so, there was a pending proceeding in federal court, an inquiry into whether Mr. Bovy and others had committed contempt of court. That proceeding was stayed by an order by two Trump appointees on the D.C. Circuit. They used a device called an administrative stay, which I think lawyers know customarily is a device to hold the status quo for a short period of time, maybe a week or two, sometimes only hours. The two Trump appointees kept this administrative stay in place for 4 months. And it was during that period of the stayed contempt proceeding involving now Judge Bovy that this committee put him through his confirmation and sent him to the floor. I think in ordinary circumstances, we would have said, wait a minute, there's a contempt proceeding pending against this individual. We should find out about that before we put him on a circuit court of appeals. But these are not ordinary times. And so Mr. Bovy was hustled through the confirmation process, and then the stay was lifted. The D.C. Circuit told the D.C. district judge, you can now go forward with a contempt proceeding. One of the same Trump judges with another Trump judge then stayed it a second time. And the D.C. Circuit has just announced that it will consider overturning that stay en banc. So that saga is going to continue. But I don't think it was a high point in the Judiciary Committee's history to put a candidate through the confirmation process with a contempt of court inquiry undecided. Now we're moving forward into Todd Blanche and his potential confirmation as Attorney General of the United States. Well, right now, there is a judicial proceeding pending in Florida regarding whether Blanche and other Confederates committed fraud upon the court in that federal district court. Just as a brief aside, fraud upon the court is about as bad as it gets for a legal officer. You can be sanctioned and disciplined for misconduct, for acting out in court, various things. You can go to being held in contempt of court, which is pretty darned serious. But fraud on the court stands apart as an allegation. My view is that this is the first time that the Department of Justice, certainly any senior officials in the Department of Justice, have ever been accused of committing fraud on a federal court. And that matter is pending down in Florida. Interestingly, the Department of Justice chose not to respond to the court when the court said, yeah, I'm going to reopen this matter and let's take a look at this. Fraud on the court for the first time in the department's history, you'd think they'd want to respond to that. Specific question about whether the actions of the DOJ comported with its own policies, something DOJ would know about. And then what about a defense memo offered by the client, the Internal Revenue Service? Again, something the DOJ would know about. And the gravamen of the issue is collusion, which takes two people on both sides of the case. So only the lawyers for Trump, his personal lawyers, answered. Despite all of those apparent invitations from the judge, the DOJ didn't answer. So we have no sense yet of what's going on. Looks like Judge Williams is going to continue that investigation. But I just think, bad as it was, to confirm a nominee to a Circuit Court of Appeals while a contempt of court inquiry was pending against that exact individual, it would be just as bad, if not worse, to go forward with Blanche's confirmation while a fraud on the court inquiry is pending against him. We have asked for documents related to that first episode, and I am asking again because we don't get a response out of the Department of Justice when we ask for documents. And I hope that we can look into this adequately to be prepared for questioning when we end up going forward. But we're in a pretty terrific position to require answers from the Department of Justice by simply saying, look, we're not going forward until we understand what the heck happened here. And if you're not answering to a federal court, well, you ought to consider answering to us as we deal with your confirmation proceedings. So I've gone a minute over my time, and it's not, again, not relevant to the candidate before us, but I did want to have a chance to make this point publicly because we're going to have to address this, and now would be a good time.
What you just heard was delivered as an aside. The senator said so himself. Not relevant to the candidate before us. He went a minute over his time. He apologized to the chairman. And in that aside, Senator Sheldon Whitehouse of Rhode Island, former United States Attorney, former Attorney General of Rhode Island, current member of the Senate Judiciary Committee, put two things into the permanent record of that committee that will not disappear when the hearing ends. The first is a pattern. The second is a pending proceeding. Understand who Whitehouse is before examining what he said. He is not a politician performing for cameras. He spent years as a federal prosecutor before entering the Senate. He knows what a contempt proceeding is. He knows what fraud upon the court means. He knows the difference between a routine administrative stay and a 4-month delay that shields a nominee from accountability. He uses those words precisely because he has spent a career in rooms where those words have institutional consequences. He opened with Emil Bove. Bove was nominated to serve on the Third Circuit Court of Appeals. At the time the Judiciary Committee considered that nomination, a contempt of court proceeding was pending against Bove in federal court. That proceeding had been paused by 2 Trump-appointed judges on the D.C. Circuit using a device called an administrative stay. Whitehouse made a point of defining that device for the record. An administrative stay is a tool used to hold the status quo for a short period of time, days, sometimes hours. It is a procedural mechanism designed to give a court time to assess a situation before it moves forward. It is not designed to suspend a proceeding for months while a nominee moves through a confirmation process. These 2 Trump-appointed judges kept that administrative stay in place for 4 months. During those 4 months, while the contempt proceeding against Bove was frozen, the Senate Judiciary Committee advanced his nomination, the full Senate confirmed him, and he was seated as a federal circuit court judge. Then the stay was lifted. Whitehouse did not characterize the judge's decision as improper. He stated the timeline. The timeline states itself. He then noted that the D.C. Circuit has announced it will consider overturning that second stay, meaning the contempt proceeding against now Judge Bove is not resolved. It is ongoing. A sitting federal circuit court judge is the subject of an unresolved contempt inquiry that was pending at the time of his confirmation and remains pending now. Whitehouse said plainly that he does not believe it was a high point in the Judiciary Committee's history to confirm a nominee while that inquiry was undecided. He said it without hedging. He said it as a matter of institutional record. Then he pivoted, and the pivot is where the statement becomes something more than a retrospective on Bove. Todd Blanche is nominated to be Attorney General of the United States. Right now, not historically, not potentially, but at this moment, there is a judicial proceeding pending in a Florida federal district court, examining whether Blanche and others committed fraud upon the court. Read that phrase carefully, fraud upon the court. Whitehouse took time to place that phrase in its proper legal context. Judicial misconduct exists on a spectrum. An attorney can be sanctioned for procedural violations. An attorney can be held in contempt of court, which Whitehouse described as pretty darn serious. But fraud upon the court stands apart. It is not a category of ordinary misconduct. It is an allegation that an officer of the court, someone with a sworn obligation to the integrity of legal proceedings, deliberately deceived the court itself. Whitehouse stated his view directly. This is, in his assessment, the first time that senior officials of the Department of Justice have ever been accused of committing fraud upon a federal court. That is not a legal finding. It is a historical characterization. but it is one placed into the committee record by a former federal prosecutor who has spent decades inside the institution making that characterization. Now consider what happened next in that Florida proceeding. The court reopened the matter and indicated it would take a closer look. That is a significant step. Courts do not routinely reopen matters. When a federal judge says she is going to re-examine a question of fraud upon the court, that signals something specific about how she views what has been placed before her. The court's questions were pointed. Did the DOJ's actions comport with its own internal policies, something the DOJ itself would know better than anyone? What about a defense memo offered by the IRS, the DOJ's client in that matter? Again, something the DOJ would have direct knowledge of. And the core allegation involves collusion, which by definition requires participants on both sides of a case. Only Trump's personal lawyers responded to the court. The Department of Justice did not answer. Whitehouse stated that plainly and let it register. A federal court reopened a fraud inquiry, directed specific questions to the Department of Justice, and the Department of Justice chose silence. The personal lawyers answered, the institution did not. He said, if you are not answering to a federal court, you ought to consider answering to us. That sentence is now in the official record of the Senate Judiciary Committee. It will be there when Blanche's confirmation hearing begins. It will be there when members of that committee formulate their questions. It will be there if the Florida proceeding produces findings that become relevant to Blanche's conduct as Attorney General. Now, two things can be true at the same time. An administrative stay is a legitimate judicial tool, and the decision of how long to maintain one is within the discretion of the issuing court. The 4-month duration Whitehouse described may reflect the complexity of the underlying proceeding rather than any improper coordination with a confirmation timeline. The judges who issued that stay did so within their authority, and attributing motive to a procedural decision is not the same as demonstrating one. On the Florida proceeding, an allegation of fraud upon the court is not a finding of fraud upon the court. The matter is pending. Blanche has not been found to have committed anything. A confirmation process that halted every time a proceeding was opened against a nominee would be a process easily weaponized by anyone willing to file a complaint. The presumption of innocence applies to nominees as it applies to defendants. Both of those are reasonable positions. So here is the question this statement leaves open, and it is genuinely two-sided. Was Senator Whitehouse conducting legitimate oversight, identifying a pattern in which pending proceedings are neutralized by strategic stays, and demanding the committee exercise its authority before confirming the nation's top law enforcement officer? Or was he using an unresolved allegation to build a procedural obstacle around a nominee his party opposes? Was the DOJ's silence in that Florida court a defensible legal strategy, or an institution refusing to answer to a court it is sworn to serve? Two different stories, same committee, same official record. Tell me in the comments which version you walked away believing. If you stayed this long subscribed, the Florida proceeding is still open.